Alors, chers
colleagues, friends, I call this meeting to order. Welcome to meeting number 81 of the House of Commons Standing Committee on Industry and Technology, pursuant to the order of reference of Monday, April 17, 2023. We are continuing our study of Bill C-34, an act to amend the Investment Canada Act. And today we are continuing our clause-by-clause consideration. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022. Members are attending in person in the room and remotely using the Zoom application. We don't have anyone on Zoom, I believe, today. Nobody on Zoom. That is correct. I would like to make a few comments for the benefits of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic and please mute yourself when you are not speaking. Secondly, although this room is equipped with a powerful audio system, feedback events can occur. These can be extremely harmful to interpreters and cause serious injuries. The most common cause of sound feedback is an earpiece which is too close to a microphone. Please be cautious when handling the earpieces, especially when your microphone or your neighbor's microphone is on, so that there is no feedback. In order to prevent incidents and safeguard the hearing health of the interpreters, please ensure that you speak into the microphone to which your headset is plugged in, and please avoid manipulating the earpiece by placing it on the table away from the microphone when it is not in use. A reminder that all comments should be addressed through the chair as much as possible. I would like to now welcome the three officials that we have with us today who know us very well. We have Mark Shan, Senior Assistant Deputy Minister, Strategy and Innovation Policy Sector, James Burns, Senior Director, Investment Review Branch, Amended, and Mehmet Karman, Senior Policy Analyst, Investment Review Branch. Thank you to the three of you for being with us yet again. And we are now ready to go back to our clause-by-clause consideration. And we were at number 7, if I remember correctly, and CPC 2 had been proposed by Mr. Perkins. So we'll start there at the amendment CPC 2.
J'ouvre le plancher, je reconnais.
You have the floor, Mr. Williams.
Yes, this is Clause 7, subsection 15.2. So the version with amendment would have an investment subject to notification under Part 3 other than investment referred to in paragraph 11.1c that would not otherwise be reviewable is reviewed under this part if, A, it falls within a prescribed specific type of business activity, then the opinion of the Governor and Council is related to Canada's cultural heritage or natural identity, and B, within 21 days after the certified date referred to in paragraph 13.1a. I, the Governor and Council, where the Governor and Council considers it a public interest of the recommendation of the Minister, issues an order for the review of the investment, and 2, the Director sends a non-Canadian making an investment a notice for review. Adding section, or number 2, would be despite the limits set out in subsections 14.3, 14.11 and 1.1 and 14.11 1 and 2. An investment is reviewable under this part regardless of its value if A, the non-Canadian making the investment is a state-owned enterprise or is controlled by a state-owned enterprise, B, the Governor and Council on the recommendation of the Minister is of the opinion that a review of the investment is in the public interest, and C, the Governor and Council issues an order of the review within 21 days after the day in which the non-Canadian gives notice to the investment to the Director. And Mr. Chair, this is really to look after what we deem to be, at this point in time, to be threats from state-owned actors into Canadian foreign direct investment, and really looking at the threshold as a whole. We had testimony specifically from Dr. Burton, which really was spelled out this whole part, which talked about that all Chinese global enterprises, for instance, and this is state-owned Chinese enterprises, are fully integrated into the PRC party, state, corporate, military, and security apparatus because, as Party General Secretary Xi Jinping put, party, government, military, civilian, and academic, east, west, north, south, and center, the party leads everything. There is no Chinese industrial enterprises existing independently from China's party state. Huawei, for example, does not self-identify as a Chinese state-owned enterprise, but like all PRC institutions, its org chart suggests that Huawei's Chinese Communist Party branch takes precedence over the Huawei Board of Directors in corporate decision-making. They also talked about how Chinese law requires that all companies and individuals cooperate with the intelligence establishment and hide that cooperation. That, combined with the Chinese regime's unrelenting cyber and human source spying on our parliament, political parties, government departments, universities, and businesses, is reason enough to conclude that foreign investment from China must be subject to the most stringent national security test, regardless of what sector or what industry the proposed investment may target. And I think I just wanted to talk really briefly, too, about all this bill, and I think it's been great, Mr. Chair, as we switch from one bill to another and go clause by clause very quickly, just how important this bill is in a larger strategy around foreign direct investment. But I think when we've gone through a lot of different instances of how important it is to look at foreign and direct investment in tangible assets, but also intangible assets, we're looking at this as a broad scope. You know, this is an important bill. I think everyone around this committee understands that. I think everyone here wants to make it great, and we've had some really incredible testimony. But this isn't a slam dunk yet, so I think when we look through amendments, we're really trying to make sure that we're looking at each aspect of this to the fullest. We ask the right questions, and then we can ensure that when this bill is passed, not only is it a bill that acts on its own, but it's also a bill that's going to work in a strategy for not only foreign direct investment, intangible asset investment, and investment as a whole. And I think one of the points that was made is we need to modernize this act to ensure that it tackles economic security as well as national security. I know that there was some instances mentioned that this bill does not do that. It just only tackles national security, but we're missing that extra component. A stat that was bandied around from 2009 to 2019, only 1% of acquisitions have been reviewed by the departments at this point. One part was that small, medium enterprises are essential to Canada and growing them, but also protecting them. How are we protecting our SMEs and ensure all small enterprises stay and grow in Canada? And is this looking only at one aspect, which are tangible aspects and not the intangible aspects? I had a colleague, Mr. Lemire, mentioned an example of the acquisition of Rona, which is really important, that the minister had set conditions, but in the end, 5 years later, there was not much left of the company in Quebec. I think the example was that there was a company, Garant Shovels, that can't always be found in Rona stores anymore. There's also the example by a Cisco Mining, which sold half of its Lac Windfall project to a South African mining company, Gulf Fields, for $600 million, of which 50% formed a joint venture, and it may not have been looked at as a whole. And it's bigger than just FDI and tangible industries. This is mostly now about intangible industries, and we're losing, like Sidewalk Labs in Toronto, like Dalhousie University, which has had Tesla investment, but all of that IP left Dalhousie and left Canada and went to the U.S. Money goes to invest in Canada, and it says, come and take our best stuff. One of the phenomena of the last 25 years has been that corporations can unbundle parts of the value chain. So we've learned, because of the incredible power of it, that corporations today in their corporate strategies can bundle, can rebundle, unbundle, and sell off an asset without shutting down the firm, and they're selling the firm out in an IPO. So, I mean, one of the questions we'll ask as part of this amendment is, are we protecting that? You know, when we look at reviews of state-owned organizations, and maybe I'll start with the officials of one question of that. When it comes to review of all state-owned organizations and understanding the significance of that, one of the first questions I have is, how are we not only looking at tangible and FDI investment, but also intangible investment in Canada and protecting the IP?
Thank you, Mr. Chair, for the question. So as noted in previous testimony, state-owned enterprises and investments, foreign direct investments from state-owned enterprises are subject to review under the national security provisions of the Act. They are also subject to net benefit if they meet the threshold test. This amendment obviously seeks to look at that threshold. With regards to intangible assets, it's worth noting that the Act already allows for us to look at the investment in the company and its assets. and that has actually been understood to include intangible assets. And in fact, without being able to speak to specific cases, I can tell you that we have reviewed transactions that were specifically related to the intangible assets of an entity, and that is part of what makes up our review, including on national security considerations.
So through you, Mr. Chair, if companies then are able to unbundle portions of, and this is what's happened with certain companies where they take some of the IP and they unbundle it, and they'll sell just that aspect or one part of the company to a foreign direct investment, and then after that sale is done, they rebundle it. We've had lots of testimony on when we looked at IP as a whole, where, and I know that one of the arguments for the minister having power himself to do reviews outside of an order in council would be that it's quick and we're operating at the speed of business, but perhaps one of the also conditions was that employees of those companies couldn't talk for 30 days or 45 days about the ideas that are part of that company, but companies are still able to unbundle parts of that. Is that something that the department's looked at? How do companies getting around the rules that are set in place? And even though this amendment might have a zero threshold, are there still ways that companies that we've heard from testimony still getting around the intangible assets and an ability to still sell them off like we've seen in Quebec and other ways?
So I would compartmentalize the question, Mr. Chair, into two parts. So one, investments into Canada from foreign actors are reviewable under the national security provisions regardless of threshold. There is no threshold, which also includes, as I noted, intangible assets and a portion or of a given entity or organization. And I am aware that we have actually utilized that power in the past. With respect to the possibility for organizations to try and sell off a portion and then rebundle that portion, I would say that those transactions are reviewable, particularly at first instance when that foreign investor is actually acquiring that. And should there be a subsequent sale, it would depend on the specifics of the use case, who was selling it and to whom, as to the interaction with the Investment Canada Act. Because if that was a subsequent sale that had already been reviewed and was now an indirect transaction, it would still be subject to national security considerations. If it was an indirect sale above threshold, it would not necessarily apply to the net benefit, because the first transaction would have, in the sense that that first transaction, either in whole or part of an organization, including their intangible assets, would have been subject to the ICA on national security guides.
Thank you. Through you, Mr. Chair. So another example that was brought up by witnesses was CRRC. So it's a Chinese railway sector company that was disqualified versus national security concerns in the U.S. Probably would not have gone through the study here in Canada. However, got through that, and that the TTC in Toronto was able to then pre-qualify that company through other tenders. One of the things we're going to get into when we talk about collaboration of this bill with other bills and with other parts of security in Canada would be, one of them is different departments, but in terms of ISED and looking at working with other elements of municipalities or provinces in Canada, how do we stop something like that from happening in the future? And we can put a zero threshold provision in this bill, but is there anything else that stops that kind of activity from happening in the future?
So, Mr. Chair, I appreciate the question, and I think one of the goals of the continued work on economic security is actually to heighten the knowledge and capacity across the entirety of the ecosystem, including other levels of government that intersect and engage with partners. That's at the root of lots of the work that's underway with research security, trying to ensure that there's a much stronger base of knowledge for all parties within the system about the ways in which they're intersecting with foreign investors and with national security and economic security concerns. Obviously, given the responsibilities set out by various levels of government, we don't have a capacity to cut off things like the ability for other levels of government to contract with entities. What we can do is control the foreign direct investment into Canada in the first place, so whether they are a legal Canadian entity for operations within Canada, and those determinations actually do come through the ICA process. And then obviously the degree to which any subsequent investments by those organizations are actually possible. So I think we need to look at the full toolkit within some of those, because obviously we can't bind municipalities or provinces to some of the what's within their full jurisdiction. But what we can do is use our toolkits and our knowledge and capacity building to ensure that everyone's at least aware of the situation and working together towards the same ends, and that we then use the ICA for where it is most useful, which is, as I say, reviewing foreign direct investment into the country, including the establishment of operations within the country.
Thank you to you, Mr. Chair. And I think you have some of those processes in the Investment Review Division, which is where you operate. There have been other instances, so where the minister, for instance, has banned Huawei from Canada. There's still, right now, universities still working with Huawei, and they're then, again, intangible assets. You know, we fund 95% of our applied research funding goes to our institutions, and we still have that threat still in those institutions taking that IP away from Canada. So again, we're not addressing it per se in this act. The question I've always, when we have one amendment, it's how are we then addressing it in other acts, because I think that's really important. Another idea that a lot of witnesses talked about was supply chain. So the current IRA is not going to shape or dictate the value chain in Canada or supply chains. One of the biggest ones that we had a lot of testimony about was critical minerals. So, you know, when we look at some of this foreign direct investment, some of the tangible assets, the IRD certainly would look at everything through a Investment Canada Act range. But when it comes to supply chains, is there anything outside of this amendment, outside of this act, which will allow the IRD to look at supply chains as a whole? I know that, and I guess maybe you could answer that with any knowledge you have on the supply chain strategy that Canada has right now.
So, Mr. Chair, I'd offer a couple of comments. So one, obviously, the current statement and guidance that we have on critical minerals is in fact attempting to ensure that the overall approach to the overall development of the industry is cognizant of the national security considerations at play, and that it is setting out the broad framework that should guide not just key decisions in terms of establishment of foreign direct investment or not, but actually the overall establishment of the critical minerals value chain within the Canadian context. That said, there are a number of other actors, and this speaks again to the capacity building that's required across the entirety of the community, because there are sector-specific regulators, including at provincial level, who have very key tools within their toolkit to be able to establish the guidance that actually sets out the minimum requirements for their sector specifically. And you raised the telecommunications sector. Obviously, that's exactly what is proposed in C26, is to actually establish the specific guidance in a sector that we have federal jurisdiction over, to say these are the minimum requirements in this sector for how we're going to continue to ensure that security is contemplated, and that we have very specific guidelines about high-risk vendors. Those same types of approaches can and should be in many cases mimicked in other sectors to ensure that where we actually have jurisdiction, that we are actually following through. But the goal of the ICA is to set the macro around foreign direct investment with the levers that it has, and then look at other mechanisms. And as I say, where we actually have those levers, we've actually done that. So in C26, that is very much exactly what we've set out. And then with critical cyber systems said, we will extend that as well into other sectors to ensure that there are minimum requirements as it relates to the cyber readiness and posture of those sectors.
And to you, Mr. Chair, then we have, you know, the Economic Development
Point
Council.
of order, Mr. Chair.
Just one moment, Mr. Williams. Mr. Gaillard.
So I think the member opposite will find support for this amendment, actually. I do have a sub-amendment that I'd like to move, if the member obviously will allow me. But again, on friendly terms.
I will defer to Mr. It's okay, Mr. Viss. I'll defer to Mr. Williams. From what I understand, MP Gaillard, you have a sub-amendment, but Mr. Williams had the floor, so I'll defer to him if he's...
And I'm happy to hear you're going to support our amendment. That's great. I don't have too much more time. I'm just trying to get a background for certain things. If you have an amendment, that's great. As soon as I have done the floor, we can go to a sub-amendment. That'll be fun.
Yes, you were next on my list, Mr. Gaillard, after Mr. Williams. Mr. Massé, and then I have Mr. Lawrence, and then I have Mr. Viss. So, Mr. Williams, floor is yours.
And thank you, and I do appreciate that. I think this is a really good discussion because, I think we started with the minister and officials, and I reread all the Hansard last night, so we had really good testimony from all over on this, and I think my point from the beginning was just to get a background, because I think a lot of the committee members had the same concerns, is that this does one thing, and a lot of witnesses did the same. And we need bills that supplement this, and we need strategies to supplement this, because we can pass this bill as parliamentarians, and a year from now we still have all these things happening, and we're going to ask why. I think the public and anyone watching and all of us here need to understand that this is one aspect, and now we need to move from this to other aspects. And what does this do, and what does it not do? So I think that's been really important. I did really wanted, because this came afterwards, I just wanted to get your opinion. C.D. Howe proposed a national security amicus, or intermediary, which was a review. It's more on the transparency aspect of this bill, but it allowed a review it was almost like a CFIUS, where they had different public members and a few judges that would review certain forms of direct investment. Was that something your department's looked at? Did you look at that briefing and see anything around that?
So we have taken a look at the report, and I think what the goal of that particular function in the CFIUS regime is to provide heightened transparency for the purposes of the investor in terms of the degree to which the process is understood from their perspective. Our regime doesn't exactly mimic CFIUS in many ways, but I would say there are a number of transparency measures that we have put in place, including annual reporting that was actually has been continuously improved in terms of both the degree and understanding of what it is that we're reporting on. And I believe that later today we'll also consider some further measures with respect to the transparency of the process, including some oversight of the national security information that's provided within the process.
Okay. And last question, then we'll go to next amendment. CFIUS, when they looked at their program and how they operate, they have a lot of involuntary submissions for FDI. Do we have any of that in Canada? Do we see that in any involuntary?
Involuntary or voluntary?
So sorry, voluntary.
Voluntary.
No, different.
Yeah, the other one's different. Yeah, way different.
Put in place the mechanism in August, and so haven't seen, don't have enough span of time yet to be able to determine. But obviously, the pre-notification measures that are placed within this bill heighten a number of what we would hope to necessarily see voluntary and actually make them mandatory. So there are a number of things that we are actually moving out of the camp of, and that's actually for the dual purpose that a voluntary regime would be. You're trying to provide the investor certainty, and from the purpose of foreign direct investment review, you're actually reviewing the stuff that you really want to review, and so therefore you're telling people this is the stuff we want to see, and therefore you're actually mandating it, and they're coming through.
Okay. Mr. Chair.
Merci beaucoup, Monsieur Williams.
Thank you very much, Mr. Williams. Mr. Gahir next.
Chair. So I think around this table you'll find great support for this bill, but and for this amendment as well. We don't want to get into amendments where we can open ourselves up to legal challenges. So I propose 3 changes, and I would like to ask the officials afterward what they think about those changes in line with the amendment. Number 1, I think we would like to change the period of time that's prescribed under Section 15 and replace 21 days with 45 days. And the 45 days would actually match other relevant review periods in the Act itself. Secondly, we would add a section to make sure that investors are notified, because it says that the non-Canadian gives notice of the investment to the director, but it doesn't actually say that the investor gets notified. And 3, that this only apply to SOEs where we do not have trade agreements, and that would protect against legal challenges from where I can see it, but I'd like to ask the officials.
Sorry, can you just clarify? Can you just repeat those last 2 points? It's really...
Okay, so the first one is 21 days to 45 days for the review period. Secondly is to add a section to make sure that investors get notified. And thirdly, that this only apply to SOEs where we do not have trade agreements.
Just a quick point of order here. I
Yes,
assume that
Mr.
you'll
Lawrence.
circulate this in both official languages? Yes.
Yes, Mr. Gahir, do you have the exact wording of the sub-amendment you're proposing that can be circulated around for
I think
members
it's been-
in both official languages? No, okay, I understand it's been circulated to the clerk, or it's about to come in, but and it will be circulated to members via email. Is that correct, Mr. Gahir?
That's
Yes.
correct.
And you had a question for the officials on your sub-amendment.
Is, in line with the amendment, and if it protects us from legal challenges, as opposed to what the amendment was originally.
I think a member for the amendments, I'll speak to the three pieces as I understand them in turn. So on 21 days versus 45 days, 21 days, just being candid with the committee, is unrealistic. The time frame to adequately evaluate a notification under the Act, analyze whether it should be reviewed for net benefit for public interest, consult with provincial and territorial stakeholders, and then perform the necessary work in order to obtain an order in council. And for anyone who's ever done that, it's not the easiest or quickest process. The 21-day timeline is highly unlikely, and I think I could probably say with relative certainty, never going to align with the Treasury Board Secretariat's filing and meeting schedule. So 45 days or prescribed period is more appropriate, as it would match the relevant review periods in the Act. So yeah, the second piece, as it relates to notice to the investor, so the existing Section 15 includes 15B2, which requires the director to provide a notice to the non-Canadian foreign investor in order to make it reviewable. So this is required not merely out of procedural fairness, but because it sets in motion a process in Section 17 where the investor is then required to file an application, and applications require more information and then documentation than just a notification. So therefore, the reference in Section 17 would need to include the new Section 15.2 in order to be able to actually trigger that whole process. Finally, as it relates to narrowing the scope of SOE investments to just those outside of whom we have a trade agreement, I think as you would have heard from me, I was going to say earlier in the week, but earlier in the week was a different bill. So last week, it's all a blur. Obviously there is some consideration to the degree to which we have trade agreement obligations and WTO obligations. Our trade agreements are specific to the fact that we are actually trying very hard to ensure that we are creating a level playing field for investments and encouraging investments between our countries. That's actually the case for a number of countries that actually feature state-owned enterprises. I know when we think about SOEs, we always think about particular countries, but actually the Canada Pension Plan Investment Board is actually, in many countries' view, a state-owned enterprise by the definition of SOE, as is the similar pension funds in a number of other countries. So limiting the scope to just those to whom we do not have a trade agreement with still causes trade risk, but obviously does not violate the trade agreements that we've actually set out and potentially disadvantage Canadian outward investment that actually would suddenly now be potentially subject to a reciprocal retaliatory net benefit, which would potentially create both uncertainty and friction into the system.
Great, thank you. So just for my colleagues, I think this is the path that actually Mr. Perkins wanted to pursue as well, the middle ground that he wanted to find.
Just, I would propose if the committee members agree just to briefly suspend so that the exact wording of what you're proposing gets circulated in proper form. Is that correct with members? For no more than 5 minutes, but so I'll suspend and everyone can. Okay. Suspend it for 5 minutes.
ask for order. Order! Thank you, Mr. Lawrence.
Welcome in this committee. And a great help for the chair. So there has been discussion amongst the parties, and I believe, I'm looking around the table, the way the sub-amendment presented by Mr. Gahir is worded needs to be a little needs to be worked on. So with unanimous consent, we could defer clause 7 at the end of the bill. So to be looked at the end of the bill, Mr. Massey.
Mr. Chair, I'm hoping we can set an example of seeing my request for the same thing was denied last time we went through this by the Liberals. So I just want to put that on the record, is that the NDP will be supporting this out of collegiality.
You are a...
I couldn't let it go. It's too much fun. It's all good.
Thank you, Mr. Massey. You set a good example. So clause 7 is reserved for a later consideration by the committee. So we're moving on to clause 8.
It's a point of order, sorry.
Yes, Mr. Lawrence.
This is clause 7, yeah. So before we move to clause 8, we have an amendment to move with a secondary amendment, different amendment, Mr. Chair, to put before the committee there. And this is this is clause 7, reference number 125-25751.
I don't have it, but the way I understand it, we just had unanimous. Do I? Just one moment.
Mr. Chair, my apologies. We'll move it when we get back to clause 7.
Yes,
Yeah.
all the amendments will be.
Yes, my apologies.
We'll be on the sub amendment of Mr. Gahir when we come back to clause 7. But we've decided unanimously to move on.
Yes.
And to reserve clause 7 for a later time.
My apologies, Mr. Chair. I'm from Finance Committee. We get things confused there.
And in the meantime, if that amendment can be shared, because I don't seem to have it. So, clause 8. Are there amendments on clause 8? Mr. Massey.
Thank you, Mr. Chair. I do have an amendment here. With section 8.1, 8.1, section 20 of the Act is amended by adding the following after paragraph
apologies,
C.
Mr. Massey. Given that you are proposing a new clause, we have to first deal with clause 8, and then we'll get to your proposed 8.1 NDP2. So shall clause 8 carry? Yes? So now, Mr. Massey, I recognize you.
Thanks. Monsieur Lemire is now lecturing me for exactly for good reason. Real quickly, I don't want to take a lot of time on this, but this raises a couple issues over privacy protection and intellectual property. They come from the experiences that we've faced with regards to protecting privacy. In particular, Angbong was an example. Out on the West Coast, and with regards to a Chinese state takeover and getting access to sensitive materials, including people's personal information through hotel and other type of measures through their seniors' residences that they purchased, as well too in Windsor NEMAC. This is about intellectual property that was developed in the auto industry, was then moved to Mexico. So this amendment here is to create more opportunity for the government and the minister to have enforcement on that, and again with the state-owned enterprises. So it comes from practical experiences that are at risk here.
Merci beaucoup, Monsieur Massé.
Thank you very much, Mr. Passé. I know Mr. Gahir wants to speak, but first I have to make a ruling regarding this amendment. So you're proposing to modify Section 20 of the Investment Canada Act, and based on the third edition of the Practice and Procedures, it says that an amendment cannot be received if it wants to modify an article that we're not seized with, or modify an article if it's not an article of the bill. Since Section 20 of the current Act is not modified by C-34, we are of the opinion that we cannot be seized with your amendment, Mr. Mass.
I recognize you, Mr. Lawrence. You understand that the chair's decision can be reversed by a vote, but it's otherwise not up for debate.
I understand, and although it seems somewhat impolite being a new member of this committee or a temporary member, I will challenge the chair.
So we'll move to a vote on the chair's decision. So shall the chair's decision be sustained?
Yes. You ready? Yes.
Mr. Sorbara.
In favor.
Mr. Gahir.
In favor?
Madame Lapointe.
Oui.
Mr. Van Bynen.
Yes.
Monsieur Genereux.
No.
Mr. Lawrence.
No.
Mr. Viss.
No.
Mr. Williams.
No.
Monsieur Lemire. No. Mr. Massey.
D'accord. Alors,
All right. So this brings us back to NDP 2. Now we can debate this, and I know Mr. Gahir wanted to speak to this.
I just want to ask the officials whether they think this is actually admissible or not.
Thank you, Mr. Chair, for the question. So we already consider these factors with respect to the nature of the law. One of the challenges of legislation is positive versus negative lists. So there are existing obligations with respect to our capacity to include and understand privacy and IP protections as it relates to the ICA. Specifying them specifically potentially suggests that other legislative obligations and considerations are actually not necessarily that which is within the purview of the Act. And so given the nature of the broad responsibility and remit we believe we have under the ICA, specifically identifying these two considerations potentially actually may challenge us in future. And is often something that we would believe would be best left to something like guidance, where we can be very specific about the fact that we actually do require this and actually think of it explicitly as something that we want to think about with respect to foreign direct investment.
thank you, Mr. Gahir. Are there any more questions or comments on NDP2? I'll recognize Mr. Williams.
Thank you, Mr. Chair. And can you maybe just walk through that? I'm seeing the two paragraphs. What on these two would stop the department from doing any of the work they're doing? How does this stop that work that the rest of the bill is carrying out?
My comment was less that it prevents this work, because we already do this work. It's the fact that by identifying this work, so notably privacy and intellectual property, that we actually potentially don't think about other aspects that are actually also legislatively required. So we have many other factors that actually we believe are factors that we consider, and also that have obligations under statute. These both have obligations under statute, and we do consider them. And so by specifying them, we believe we're actually potentially preventing us from someone saying, well, you're not allowed to look at other things because the only two that you put in the Act were these two.
Thank you to you, Mr. Chair. So where I would challenge that is, I think in testimony, and we've talked about a lot in this, that we're not going to put lists and critical lists into the Act because it would be hard to undo them. That, I think, what I understood is everything will be done through regulation. So in regulation, and I think there's a lot of different testimony we have on that. But I think unless we have another Act that spells this out, this would, at least in the interim, point to intellectual property, which we had multitudes of witnesses testify stating how important it was that we looked at that. And I think the only risk I see is that if we don't reopen this ICA again for 22 years, that we might have to remove it. But I don't see a risk at this point because there's no other Act that points to that. So meaning, besides leaving out the list that will be done in regulation, which talks to more of the industries that we'll be looking at, this does talk about intangible assets, intellectual property, and protection personal information in Canadians, which was two parts. And I think we had one witness, Mr. Balsillie, who made specific mention to both IP and data. and we have a lot of witnesses that back that up. This seems to me that it comes directly from personal testimony, but I think the risk of having this baked in legislation that it may affect the future as opposed to the list that will be in regulation, I don't see that in there. So is that something you agree with or disagree with?
So with respect, Mr. Chair, I would disagree. So privacy rights, particularly as they're spelled out here, actually speak to legislative and statutory obligations that exist under the Personal Information and Protection of Electronic Documents Act. And where it speaks to intellectual property rights, those are actually spelled out in the Patent Act, in the Trademark Act, and in the Industrial Designs Act. And so the degree to which this actually specifies rights that are specific, but doesn't actually list all of the other acts that we care about or that also come into play and should be respected, runs the risk actually of having the contention that the government didn't think about them, and therefore they're out of bounds. With respect to the contention that we need to care about these, I would very much contend that the broad capacity of the ICA to look at factors related to investment in Canada includes intangible assets and privacy considerations. And in fact, I know of a very specific case in which intangible assets and intellectual property rights was specific to the considerations that were given under the ICA.
Thank you, Mr. Chair.
I can't share that because it's a case.
Thank you very much. I have Mr. Lawrence, then Mr. Viss, Mr. Sobrero, and Mr. Massey. So, Mr. Lawrence.
Thank you very much. And I'll continue on with yourself, Mr. Sean. I understand you've been very active, and we appreciate all the time that you've spent with this legislation. It's very important. I appreciate your service as well. I'm just so your contention is that by specifying these two items, we could have the effect of excluding other items. So want to be as constructive and helpful as I can be. I do believe that these are excellent suggestions. I understand what you're saying, that you already included in that, but I guess the old saying of trust but verify, and I understand you're doing a great job, but there's no guarantee that unless this is written in law by Parliament that it will continue on. Regulations can be passed by the government. Your internal guidance can change whenever you want it to change. And so I think these are critical things that need to be written down. So, but my constructive question for you is, do you believe it would be helpful if we sub-amended this to say that this was just one of many different things that the department should consider?
So the factors that are currently listed in Section 20 are intentionally broad. So the effect of the investment on the level and nature of economic activity in Canada, including without limiting the generality of the foregoing, the effect on employment, on resource processing, on the utilization of parts, components, services. I won't read them all, but needless to say, Section 20 right now has intentionally broad parameters for the purposes of trying to ensure that we can contemplate a number of factors. Suggesting that in addition, non-exclusive these other aspects, I think we'd have to think about. I would note there are existing guidelines. You were asking whether or not this is written down. Our existing guidelines on the National Security Review of Investments state that the transfer of sensitive technology and intellectual property is considered during National Security Review, which applies to all foreign investments regardless of size, and to IP regardless of whether or not it is government funded. And so just to note, if the request is intellectual property should be written down somewhere, IP is written down in our National Security Review of Investments.
I understand that, but putting these in, I think, are critical, especially with respect to the examples Mr. Massey gave, and fully supportive in there. And it's been a while since I was at law school, but I think back in studying law in law school, that when we're interpreting legislation, unless there's something that says exclusive or limited by or language analogous, there's no way that this would ever in any way limit your ability. That's just not the way that the laws are interpreted.
So the intentional inclusion of additional categories to law is actually often inserted as having rationale. So
But
jurisprudence
it's not
has
excluding
routinely
any-
returned to the position of whether or not what the government meant by specifically adding in clauses and not others. That's actually been a subject of considerable jurisprudence over the years in terms of whether or not the government meant to actually exclude other things, because obviously it was intentional about giving itself the right to do something it could already do. So if it could already do it, why did it specify these things? It obviously might be suggesting that actually it was at the expense of what it could also do in other zones.
But there are provisions in the Income Tax Act, and I apologize, I don't have them off the top of my head, but I'm happy to provide them to you, sir, where it's highlighted certain items, but it's not exclusive. In fact, it's quite common in the Income Tax Act. That's my area of expertise to do that, where it will enumerate 4 or 5 or 10 or 15 or 20 different items, but then say that list is not exclusive, which is exactly what this does. So there's no legal principle that I can see that would exclude. Show me the language in here that says that other factors would be excluded.
So right now the language is exclusive in that the factors, right now there is no such clause at the end of the factors. So by specifying them, you would potentially risk that.
So would you, if we put a sub-amendment in, they said that has got to alleviate your concerns, no?
Well, so I would raise a potential other concern, which is one of the things that, notwithstanding the overtly broad and purposeful nature of the factors, is also to balance that with the desire for some degree of certainty, which is if this is non-exhaustive and suddenly you can throw in whatever else you want to consider, you're actually bringing uncertainty to potential investors, because now you've actually so the balance is a broad enough basket that says you can look at the important things. Here they are broadly constituted, which gives certainty to the investor that you can't just make up stuff as you go along and think about and add other factors, while also being broad enough, as I say, to get at what's important.
Are these enumerated factors in this amendment outside of the current scope, or are they within the current scope?
We believe them to be within the current scope, which is why it's problematic to potentially add them in, because we believe that we already have the power to do this, and we have.
But I don't understand. Like here's the deal, right? We're in Parliament. I work for the Canadian public. You work for the Canadian public, right? And if we want certainty, that has to come from the Canadian public, not from you, not from you. Okay? You don't pass laws. We do. We want this in here, because this adds certainty. We don't trust you, to be clear, for you not to include
Mr. Lawrence, just to be clear, okay, the officials are here to answer questions that are technical in nature, specific to the bill before us. They're not here to debate the policy rationale or the intent. I mean, we have to keep it at on a certain tone, Mr. Lawrence. I hope you maintain that tone for the rest of your time with us.
I wouldn't want to divide and stigmatize. Mr. Leibach.
Yes, thank you, Mr. Lawrence.
If I get passionate, I apologize, Mr. Chair. It's not directed. Like I said, I thank you for your service. I just don't think what you're saying candidly makes sense, and I think I should be able to allow to say that as a legislator, as a representative of the Canadian public. Why can we not highlight certain categories within a broader category? It doesn't exclude any. And if it does, then maybe we should work to get a sub-amendment if that would alleviate. Like that's where I want to go. I want this to be good law, but I want to make sure that these two highlighted things are highlighted. I'll yield the floor at that point, but if you can put me back on the list, I just want to think about this for a second.
Thank you, Mr. Lawrence. Mr. Viss.
I was reading in a Globe and Mail article from Niall McGee from August 13th, 2022. China has encroached on Canada's critical mineral industry with almost no obstruction from Ottawa. In the article, it states, while Canadian politicians claim to want to scrutinize foreign takeovers, over the past 5 years, fewer than 1% have been subject to in-depth security reviews under Section 25.3 of the National Security Act, and almost none were blocked. Last year, out of 826 foreign investment filings, Canada conducted only 11 Section 25.3 reviews. The government blocked only one of those transactions, Chinese state-owned Shandong Gold Mining Co. Limited's attempted takeover of a Canadian gold mining company TMAC Resources, Inc. There was another example that was listed, I believe it was Norsat Technologies, where I believe Mr. Massey's amendment comes from. I think he's nodding in agreement with me, where intellectual property was indeed lost. And the general mood of the Canadian public is that they want this bill strengthened, and I'm glad the government brought this forward. But I don't know if the regulatory approach has done its due diligence. Now, under the Australian laws, they have the ability to go back. So my question to the official is, have any analysts in your department examined Bill C-34 in the context of, say, Bill C-34 had been in place 5 years ago, how many more transactions would have been covered under Section 25.3 of the National Security Act, under Section 25.3 of the Act in the context of critical takeovers by foreign state-owned enterprises?
I'm not in a position to answer the question that was put by the member. Section 25.3 is a fact-based, use case specific case that's determined in consult with the national security community as to whether or not a given investment meets the test of would be injurious to national security. And so Section C-34 makes important improvements in a number of ways, but the degree to be able to go back and determine whether or not the national security advice would suddenly rise to the threshold of would is not something I'm in a position to answer.
My problem, Mr. Chair, with I think everyone wants to get this legislation correct, but the problem is I don't think as a committee we have all of the relevant information as the Act applies. We've heard from officials, and I know they're subject, and I'm not challenging the officials on this, but they're subject to security provisions that they have to uphold as officials. But us as legislators, we're asked to basically make amendments to one of the most consequential bills for business activity in Canada without access to the confidential information that informed the approach that informed the decision makers at the Department of Industry. And that's why I tend to side with Mr. Massey on the need for more explicit lists in the bill to provide the assurances that British Columbians especially want after, and I would say all Canadians, in British Columbia it's particularly bad, want to see from this legislation to see that we're protected. I don't have anything else to add on this amendment other than the fact that I think we should move a sub-amendment to alleviate the concerns raised by the officials and ensure that it wouldn't, under future legal interpretation, be subjected to help me out here, Phil. Be subjected to an interpretation that would exclude other factors by the inclusion of the two factors right here. So with that, I'd like to move a sub-amendment that clauses C1 and C2 that we say that it doesn't exclude any other considerations made by officials or the minister in conjunction with these with these provisions at hand.
Okay, just 1 second. Mr. Viss, you're aware that we would need, considering you're moving a sub-amendment, we would need the exact language in both official languages. Do you have the exact wording? My guess is no.
I don't, but if we recess for a second, I can write it up.
If with the committee's consent, we can suspend for a couple minutes. So, meeting suspended.
conversations between parties. So there's unanimous consent. So we will do the same as we did with the clause 7. With this new clause, we will talk about it at the end of the bill. So we will talk about the other bills first. So I'll open the floor. Is this the unit? Is there UC? Yes. So let's go to the clause 9. Is there amendments that are tabled concerning this clause? So if there's no amendment,
Clause 9, and no one to move an amendment on Clause 9. Mr. Williams.
Thank you, Mr. Chair. So we're moving, this is a reference number 124577710. And this is an amendment that Bill C-34 in Clause 9 be amended by adding after line 26 on page 6 the following. 7, Section 21 of the Act is amended by adding the following after subsection 8. 8.1, the minister shall provide reasons for any decision made under subsection 21, 1, 22, 2, or 23, 3, explaining the factors taken into account by the minister to include that he or she is satisfied or is not satisfied that the investment is likely to be of net benefit to Canada, and shall publish in the Canada Gazette any order imposing terms and conditions on the investment implicated or proposed by a non-Canadian. This amendment, we think, just makes, to what our point is transparency, bring a little bit more transparency to the role. We heard from multiple witnesses that they'd like to see more transparency in government. We certainly heard from witnesses from CFIUS in the U.S. where they include a little bit more transparency. We even have a public portion into that committee, and this was our attempt to add that to this bill, Mr. Chair.
Thank you, Mr. Williams. Ceci étant, j'ai une décision de la
so there is now a ruling from the chair concerning CPC 3. Bill C-34 amends the Investment Act, among other things, authorizing the Minister of Industry, after consultation with the Minister of Public Safety and Emergency Preparedness, to impose interim conditions or investments to prevent national security breaches that may occur during the review, to issue an order extending the review under Part 4.1 and allowing written undertakings to be submitted to the Minister of Industry to address national security risks, and provide that he may, with the agreement of the minister, terminate the review as a result of the undertakings given. The amendment adds a new requirement for the minister to provide reasons for decisions made under subsections 21.1, 22.2, 23.3, setting out the factors that he has considered in concluding whether or not he is of the opinion that the investment is likely to be of net benefit to Canada. There's no provision in the bill to provide such reasons. According to the House of Commons Procedures and Practice, an amendment to a bill referred to a committee after second reading is out of order if it goes beyond the scope and principle of the bill. The chair is of the opinion that, for the reason mentioned above, the amendment goes beyond the scope of the bill, therefore declare the amendment inadmissible.
Looking at Mr.
Yes,
Chair.
I'm waiting for you to challenge.
I'm going to be polite there, and we will not be challenging the chair on this.
OK. Donc, l'amendement est recevable.
So the amendment is inadmissible. So let's go to the clause 9. Is it, shall we pass clause 9?
Maintenant, il y a, est-ce qu'il y a un amendement?
Is there another amendment before going to clause 10?
Massé.
It's NDP 3. And Article 9.1. 23.1 of the Act is replaced by the following.
So, Mr. Massé, the floor is yours for NDP 3.
That the minister shall provide reasons for any decision made under paragraph 23 3B, and the minister may provide reasons for any decision made under subsection 21 or 22.2 or paragraph 23.3a. The reasons shall include information on any representations made or undertakings submitted by the applicant. This is for more transparency and for the minister to have to justify the decision-making process.
Merci, Monsieur Massé.
Thank you, Mr. Massé. I will have once again to inform you of the decision by the chair. The amendment seeks to amend the section 23.1 of Investment Canada Act. An amendment is inadmissible if it seeks to modify a legislative text that is not before the committee, or if it seeks to modify a section of the existing law, unless the latter is explicitly modified by a section of the bill. So according to the chair, the amendment is inadmissible based on this reason. So I see that my decision is not being challenged. The amendment is deemed inadmissible. So now we go to clause 10.
I have CPC 4 there. Is that, or am I on Article 9 there, Mr. Chair?
I believe.
Or 9.1, my apologies.
Are okay. Yes, CPC 4 can be moved. Who's moving it? Mr. Généreux?
Alors, CPC 4.
So CPC 4. The bill C-34 be amended by adding line after line 26 on page 6 the following new clause. 23.1, the minister shall provide reasons for any decision made under subsection 21.1, 22.2, and 23.3, explaining the factors taken into account by the minister to conclude that he or she is satisfied or is not satisfied that the investment is likely to be of net benefit to Canada, and shall publish in the Canada Gazette any order imposing terms and conditions on the investment implemented or proposed by a non-Canadian. I don't know if the ruling of the chair will be the same as the two other rulings. We would like to see this new amendment in the bill. The NDP and Conservatives want to propose this amendment, and there's a valid justification to do so. And we would like to include this element in the bill. So despite your rulings, we will have to try to find another way to include these proposed amendments. Thank you, Mr. Généreux. You're right. The amendment seeks to amend Section 23.1 of the Investment Canada Act. So according to the House of Commons Procedures and Practice, an amendment to a bill referred to a committee after second reading is out of order if it goes beyond the scope of the end principle of the bill. So, according to the chair, the new amendment is inadmissible. I see that there is no challenging of my ruling. So let's go back to the clause 10.
Okay,
Yeah.
I didn't recognize you in time, so I'll accept your challenge to the chair's decision. But please, if I'm speaking too quickly, let me know. Otherwise, pay attention.
I'm trying to listen in French, and then
It got lost in translation. But I'll accept your challenge to the chair's decision which deemed irreceivable CPC 4. So the decision is challenged. Shall the chair's decision be sustained?
Yes, it shall.
Mr. Sorbara.
In favor, yes.
Mr. Gahir.
In favor?
Madame Lapointe.
Oui.
Mr. Van Bynen.
Yes.
Mr. Genereux.
No.
Mr. Lawrence.
No.
Mr. Viss.
No.
Mr. Williams.
No.
Monsieur Lemire.
Oui.
Mr. Massey.
Donc, la décision n'est pas renversée, ce qui nous amène à l'article 10.
So we are now at clause 10. Are there new amendments to clause 10?
And carry. Yes. Clause 11, are there any amendments to clause 11? Shall clause 11 carry? Yes. Clause 12, are there amendments that members wish to move on clause 12? Mr. Williams.
Thank you, Mr. Chair. And we have Amendment CPC 5, that Bill C-34 in Clause 12 be amended by replacing line 11 on page 7 with the following, quote, manner described in Section 28, B1, if the non-Canadian is a state-owned enterprise to acquire any of the assets of a Canadian business or. And this was added, I think, subsequent to other additions we'd have to make sure that we are identifying state-owned enterprises and ensuring that they're looked differently than other FDI. Thank you, Mr. Chair.
Thank you, Mr. Williams. I recognize Mr. Fillmore.
Thanks, Mr. Chair. I just want to reflect for a moment and then perhaps propose a friendly amendment to the amendment that might achieve the same intention, but perhaps a bit more effectively or with more clarity. I might ask the officials to weigh in on what I propose. I guess it starts with saying that the amendment seeks to expand the jurisdiction to asset sales, and those asset sales are actually already covered in the bill as is. It may not be clear, and I think that's what the point of the proposed amendment is. So what I just want to remind members that all acquisitions of IP assets are already subject to national security review under the ICA, whether the investor is a state-owned entity or not. The concern with the amendment is that it could be interpreted as actually narrowing the scope of this national security review for such asset acquisitions under the Act. And the proposal, therefore, is to adjust the language so that we can really cement the interpretation in there that any acquisition of an IP asset can be reviewed regardless of who the investor is. So the proposal the change I'm proposing is at 25.1 sub C.1, the text, for greater certainty, the acquisition in whole or in part of an entity under paragraph C includes the acquisition of the assets of such an entity. And I wonder if perhaps the officials might have something to say there.
Just before Mr. Shan, I let you react. Mr. Fillmore, you're moving a sub-amendment. Has it been provided to the clerk in writing in both official languages? And if not, would it be possible to do
We
it?
will make sure that's happening right now, yeah.
Thank you very much. Mr. Shan.
Thank you, Mr. Chair. I would concur with the assessment that was provided in that the ICA has jurisdiction on assets, but that the amendment would require, or that this definition would essentially ensure that it's understood to include assets for which we believe the Act already applies and would specify those. And so the for greater certainty clause, we believe, just reinforces what we believe the Act is capable of doing, but draws attention to it, which is helpful.
Thank you. I'm just validating to see if the wording, so it's not been received yet, and I would like for members to have it before they can debate it.
I think it's coming. Maybe a very short suspension.
Okay, very short suspension until the sub-amendment from the floor from Mr. Fillmore is received. Suspended.
We're back. We're still on Clause 12. There was a sub-amendment that was proposed by Mr. Fillmore, but considering...
As it should, for a sub-amendment, I would seek unanimous consent to reserve Clause 12 for further consideration, Clause 12 altogether. So the amendments that you had moved, Mr. Williams or Mr. Perkins, I don't remember who moved it, but yeah. So we'll reserve it with unanimous consent and get back with a proper deal. Okay, so with unanimous consent, Clause 12 altogether is reserved for a later time when we finish at the end of the bill. Moving on now to Clause 13. Are there any amendments to Clause 13? Shall Clause 13 carry? Yes. We're making progress. Thank you, Mr. Massé, for your enthusiasm. We'll now move to Clause 14. Are there amendments to be moved on Clause 14? Mr. Perkins.
Bear with me while I flip some papers here. 2 committees in the same 2 hours is a little challenging. So, okay. So, CPC 7. So, Bill C-34 in its current form, it doesn't compel the minister to actually, in my view, conduct the national security review. I know we had some discussions and questions about that. Mr. Shen said there are, I think, 3 levels, and or stages. What we're looking for is that the minister, in the case of something, doesn't have the option, basically, of asking for the more detailed reviews in the 2nd and 3rd stages, that he shall do it in certain circumstances. My understanding is that the word may and shall in legal terms have very significantly different meaning. And so the purpose of this amendment is to compel, in other words, the minister to send certain types of investments to a national security review rather than giving the option. And part of the reason for that is I've expressed before my concern that several acquisitions recently by companies controlled directly and indirectly by China, the Communist Party of China, were allowed to go through with a fairly, what I call, in a non-technical term, fairly superficial national security view, and I'm thinking primarily of the acquisition of the telecommunications company in Vancouver called Norsat, which was bought by Hytera, and which in subsequent it also owns the Toronto-based company or American-based company Sinclair, which subsequently was contracted by both RCMP and Canadian Border Service Agency to provide services, equipment to those agencies after the United States and President Biden had actually banned Hytera from doing business in the United States and had actually been charged and has been charged in the United States with 21 counts of espionage. So to me, and while that's not an acquisition of sorts in terms of the procurement, the whole idea that Hytera itself was able to buy important telecommunications equipment with the minister having the ability to say, well, I may, so I'll just do the basic level security and I'll not do the deeper dive on the state-owned enterprise. We need to have a greater depth of certainty in the national security view in those cases. The other case that I had mentioned at a previous committee was the acquisition of the Tanko mine in Manitoba by a state-owned resource company in in China, based out of Beijing, I believe, that acquired at that time the only producing lithium mine in Canada, obviously critical to the EV strategy going forward for our country. And the result of that is all the lithium being mined in that mine in Manitoba, our only one, is actually going to China to develop the battery technology in China rather than being used here in Canada. And again, that went through under Minister Baines, just the cursory first level review, and was not compelled to go into the more detailed review. And I know there are examples that go further back that people would probably like to talk about. I know that Mr. Massey and I have talked about, for example, Nexan and the oil sands, and the list goes on and on and on. And so we feel that in those circumstances that it's essential that the government and the cabinet have the benefit of that detailed security review, that it shouldn't be an option, that it should be required, or should be a shall rather than a may.
Merci beaucoup, Monsieur Perkins.
Thank you very much, Mr. Perkins. Unfortunately, there's a decision from the chair. C-34 authorizes the Minister of Industry to make an order extending the ruling under Part 4. 1. Amendment CPC 7 removes the Minister's authority to make such decisions and grants the authority to the Governor and Council instead. In House of Commons Procedure and Practice, 3rd edition, on page 770, it states, an amendment to a bill referred to a committee after second reading is out of order if it goes beyond the scope and principle of the bill. The chair is of the opinion that for the reasons mentioned above, the amendment runs counter to the principle of the bill. Therefore, the chair declares this amendment inadmissible. Yes, Mr. Perkins?
I believe in this amendment and the one after it so much I would like to challenge the chair and ask for a vote on that ruling, please.
Such is your right. So shall the chair's decision be sustained, Madam Clerk?
Mr. Fillmore.
It shall.
Mr. Sorbera.
In favor, yes.
Mr. Gahir.
In favor?
Madame Lapointe.
Oui.
Mr. Van Bynen.
Yes.
Mr. Généreux.
No.
Mr. Perkins.
No.
Mr. Viss.
No.
Mr. Williams.
No.
Monsieur Lemire. Oui. Mr. Massey.
No.
5 nays.
So the amendment CPC 7 is irreceivable in the decision. The challenge has failed, which brings us to, well, are there other amendments regarding Clause 14? Mr. Williams.
Mr. Chair, we have CPC 8, which replaces line 28 on page 7 with "Jurious to national security, the minister shall," within the, and replacing line 31 on page 7 with the following: "It is to be made under subsection 25(3). And we're doing this one because several MPs have expressed the need to create an automatic trigger that compels the minister to conduct a national security or net benefit review when within that threshold. While the bill does provide greater power to the minister to conduct a net benefit and national security review, their minister may ultimately choose not to conduct a view." I think this also goes to, well, we heard from the minister that he would like more power. At the end of the day, we've seen certain examples where the minister has chosen, like Neo Lithium or others, to not use that power. This part of the bill would ensure that the minister would have to if there was an automatic trigger.
Merci beaucoup.
Thank you very much, Mr. Williams. Are there any more comments or more discussions on CPC 8?
Shall oui, Monsieur Perkins.
So just to add, this is again similar, I understand, to my presentation on the last one, but from the perspective, again, of the fact that I think when the minister was here at one of the meetings, I said, not all ministers are created equal, regardless of party, in it, and some perhaps aren't as diligent as the current minister in the role. And I know he has put out more stringent guidelines on some of these areas, particularly in the critical minerals area. So clearly, this current minister is looking a little more rigorously at it than perhaps previous ministers, but still those things are in guidelines and not in law. So the idea that he is required to, as a shall, to have this in both net benefit review and national security ensures that the Governing Council, Cabinet, and the Minister himself has the utmost detail available in making the final recommendation to Cabinet or final decision to make sure that the net benefit and the security interests of our country are well regarded and well protected when there is an acquisition, which I believe is essential. I think it's proven that ministers are not necessarily, in some instances, following the due diligence that one would expect from the public. They may be getting advice from the department in the official process that says, okay, we've done a first level assessment and it looks okay, or the Minister of Public Safety says it's okay, or we think that we don't think that it's an issue on net benefit, even though we don't have, not to mix bills, but even though we don't have a real beneficial corporate registry that can make clarity to us about concentration levels of companies within particular industries or areas. And as I had mentioned earlier, the Fisheries Department doesn't know actually who ultimately is the beneficial owner of the license, so can't tell whether or not in the West Coast, for example, Jimmy Pattison has 50% ownership of all licenses, and the Competition Tribunal says that shouldn't be in any industry over 30%, as we know from our discussions around Roger Shaw. So I know this seems a little circular, but I think it's incumbent upon us to make sure that whoever the minister is, and ministers change and governments change, that the due diligence is done so that the minister has the full depth of information available to them from all the security experts or all the competition experts on corporate concentration and net benefit analysis before making that final decision in certain circumstances to ensure that our interests are well protected. And I think the problem with the language "may" is it may not be a minister that is as diligent. And it may not be, or it may be in some circumstances, but it leaves it to the chance and the vagaries of who occupies the office. And it's nothing to do with the current government, because I can make the same argument about some people in the past government too, preceding it, who held this job. And I'm sure, the officials would never be so impolitic as to probably share with us their views on the long list of previous ministers and their diligence or not on some of these issues. But I think this takes that guesswork out of whether or not this happens, and the situation where we have in Parliament members of Parliament coming hard at the government of the day, questioning why they did not do this, why they didn't do the in-depth, as happened in the Tanco case and as happened in the case of Hytera. And I wasn't around on the times of the Nexan purchase in the oil sands, but I know Mr. Massey was, and I know, at least I understand from him, that he raised some of these issues in the House. And this would protect the minister in large extent from having made perhaps an error after the fact and being subjected to the questioning of the decision without the proper information handed to them, where they can't put the toothpaste back in the tube. Once it's approved, it's done. It's over. You can't go back. And so having more information is only a good thing in this process. More certainty for ministers and governments to have more information in making that final decision. And in the case, as I understand it, I believe in the process, if there is viewed to be a national security issue out of that review or a net benefit issue out of that review, the minister, I think, under the Investment Canada Act, then has to go to the Governor and Council and with a recommendation. And the Governor and Council, for those who are watching and don't understand what that's a cabinet. It has to go to cabinet to get agreement on the decision or recommendation they're making if there's an issue with the net benefit review or a national security review. And in my days when I had hair, I sat as a staffer behind in cabinet meetings, so I saw some of that debate behind the curtain. And certainly in my years around executive and board tables in the private sector, I know that in the decision-making process, there is a more robust and better decision always made when you have a lot of people around the table with varying backgrounds who can give their opinion and not just the opinion of a single person like the minister. And that's why it goes to cabinet, to have those discussions, because while the minister may think that it is or isn't an issue, there may be a different perspective, regional perspective, other perspectives from different backgrounds around cabinet, and quite often the decision that comes out of cabinet may be a little different than what went in. But it will never go there for that debate if the information and the depth that we're asking for here isn't done, and therefore not going to the minister to make sure he or she has the full benefit of everything possible in making that recommendation forward. So it seems like a small change because it's may and shall. I thought it should be will, but the lawyers told me we don't put that in the act. You don't use will, that the minister will do this, that the minister shall do that. That's essentially will, apparently. The chair is a lawyer, so he knows this better than I, but will is not apparently a word you use in act. So I would encourage all members to think of that around the table and to say, why would you not want to have the minister have the full breadth of expertise and information before him at the highest level of detail that we can get in this government on an acquisition on national security and net benefit. In case the fact that, and I'll say, in case the fact you get a lazy minister, really, there are some lazy ministers, and a lazy minister may actually not really read the brief and not do the due diligence in looking through all the documents, and may not spend the time with officials to fully understand what this acquisition is about and what's happening. And therefore, the government and taxpayers and industry are exposed to things that we shouldn't be exposed to. So one of the guarantees, I guess, against the lazy minister is turning may to shall. So what I would ask you to do is to support us in this proposal to protect us from lazy ministers and to make sure that all of the information that is possibly had is available to that minister, whether they are diligent or less diligent going forward.
Fascinating, Mr. Perkins. Thank you very much. It was interesting. Mr. Massey.
Thank you, Mr. Chair. And I'll be supporting this as well. And I think that we could maybe aptly name this amendment the Maxime Bernier Clause, because he was minister. Because he was minister at one point in time, and that should give a lot of concern for Canadians. These are just simple facts. That I've lived through here. Not looking to attack anyone or anything. I didn't have any trouble with him as minister, but I could say that the current minister is actually, I'll be quite frank, has worked a lot harder in many respects. And I put that on the public record any time, any place, anywhere, as well as other ministers that I've had.
It's already on Twitter.
Yeah, it's already there. Yeah, absolutely. So, and I understand the clause about shall and may because I worked with then Minister Cannon to change that language to ensure the consultations under the International Bridge and Tunnel Act to actually consult the local communities where the municipality was hosted, where before they didn't have to be. So I'll support this amendment for those reasons and appreciate the efforts of Mr. Perkins on this, and I'm ready to support it. Thank you.
Are there any more comments on CPC 8? Monsieur Généreux.
En fait, Monsieur le Président,
Mr. Chair, I will say something similar to my colleague. We had a great many witnesses, and they talked about having an automatic trigger for acquisitions. I think that it's a very important element. In changing the words here, will you have to challenge this, Mr. Chair, or will it? I would like for you to explain the difference between this one and previous amendments. It does not go beyond the scope of the bill. I would like to ask the officials then, in your view, in changing the terminology here, would the minister have more power, or would it give more latitude to the minister? This amendment would limit the minister's discretion because it requires that the minister proceed to 25.2, the second level of the process for national security. It doesn't give them more power because it reduces their discretionary power. You said reduce the minister's power, right? Reduce the minister's power? Yes, because they wouldn't be able to examine things step by step, the national security implications. Usually, there would be a national security review. There's the decision to move on to the second phase with 25.2, and then there's a decision to move on to 25.3, and then they can issue an order with 25.4. With this amendment, it would require that the minister move to 25.2. Usually, information is collected with 25.1, and then there's a decision, and an investment might trigger a review. So it reduces the minister's power. I'm not sure that I follow you, because the minister, with all these steps, will still be able to decide, regardless of this change, whether or not to go further in the review. So I'm not sure I follow, because the minister can continue to decide to do the review even if we change the wording. Currently, there is the cabinet that must make a decision with ministers, but in fact it makes a decision for the minister because it requires that the minister move on to 25.2. Oh, we've lost our chair. Her chair disappeared. Okay. So it becomes an automatic trigger, and I think it is important to have this. To respond to your question, Monsieur Généreux, CPC 8 is admissible because CPC 8 remains at the minister level. Mr. Perkins.
If I could just follow up on my colleague, Mr. Généreux's question. Mr. Chen, I get that it does remove that, so I agree. It's narrowing on the process. So it's doing the intent, which is to get a deeper dive into these issues for the minister. But it doesn't change the ultimate decision-making process the minister has from the results of the review by those agencies. The minister still has to review that. It doesn't restrict their ability, in my understanding. Once the recommendations come back from those reviews, the minister still has decision-making power. It hasn't changed on what to do with that information from those and whether or not the minister believes, if I'm correct, that there is a net benefit issue or a national security issue, and then make the decision whether or not to go to cabinet with that. So it doesn't remove his discretion, his or her discretion in that, I don't believe. Is that correct? Just in, it forces a process, but not predetermines the result.
So it's important to note that there's two aspects to this. As you note, there's the process that follows from the decision, but the process is based on the information. So the movement from 25.1 to 25.2 to 25.3 is an escalating view of the national security evidence, that it moves from a concern that there is a national security consideration worth evaluating, and that's the beginning of the process, that it could be injurious, and it's the information that makes the determination on the basis of whether or not it moves to the next step. So what this does is essentially, in process, makes a determination without the information that it must proceed to the next step. You are correct, though, that it does not bind the minister into an outcome based on that information. But normally the 25.1 to 25.2 to 25.3 is additional information and further scrutiny on the basis of the new information that follows, because the information actually is a further assessment.
So I would actually think that's a good thing. So it doesn't bind him on the outcome that he or she as a minister wants to do in recommending going forward, but it does ensure that the minister has a deeper level of information than the first level of review would probably give them. It may or may not, I guess. It's not, it all depends on the situation. It may confirm that it's not an issue, for example, that you might have been able to get that from the first level, or you may not. But it may provide a more robust amount of information. So it guarantees that there's a little deeper dive on the information that goes in. It may result in the same information going back, but we don't know if it would result in more unless the minister goes to that level. Or the process makes the minister go to that level. Is that correct? So, if you can follow, I don't know if people are following. It may sound a little circular, but
I am following. I mean, right now, the movement from one level or one stage of the national security review to the next is premised on the analysis of the information. And so by moving, by essentially assuming a 25.2 review, one is presuming that the information necessitates it. Whereas that analysis in the current format is, here's the information, an assessment is made as to whether or not we actually need to and believe it to be that it could be injurious. Further analysis and assessment is done then to move it to the next level where it's believed that it would be injurious. And so by moving to 25.2, the information, it's not following the information escalation that currently happens now, where essentially we're coming to a series of cascading decisions. Is there a national security concern? Is that national security concern founded? Does it actually, could it be injurious to the national security of Canada? Would it be injurious to the national security of Canada? So by jumping through to the next set of questions, we have presumed that the answer is yes and yes. And in our current world, we allow the information to speak to whether or not the answer is yes.
But if you skip to that, you're still going to have, presumably, the information from the other two levels, in the sense that that at that next level it would say, let's take the case that you've determined it's not. You would still get that at this level, even though it's a little deeper. It said, okay, well, this isn't going to take long.
The national security community to further assess something that they do not believe to have national security risk, to now further assess it as to whether or not it really doesn't, because you've asked it to basically have a could test.
And I know you can't divulge the past decisions, But my understanding of the cases that I mentioned by the public information that was available from the minister at the time is, for some reason, in the case of Tanko, for example, it was determined at the first level that there wasn't a national security interest. We never went any deeper thought, when obviously we knew it was being bought by essentially a Chinese state-owned enterprise for our only lithium mine. So what I'm struggling with is that I think the process doesn't work. When that happens at the first level, according to Minister Baines and according to all the media I read on it, that's as far as that analysis went in that case. It doesn't work if that level alone says, okay, we don't think there is, so go ahead. And then, of course, it turns out that the company and the plan and everything they're doing, to me, is injurious to our net benefit and national security, because 100% of what's coming out of that mine is going straight to China and not being managed at all here. So the motivations of the company buying, their intent of what the company's buying, all of those things clearly weren't exposed in that first level, or one might have thought that it should automatically go to the second or third level. And not having gone, I actually haven't seen this, because this sort of level of stuff was long before I ever sat as a staffer in a cabinet meeting. The world didn't have much in the way of free trade of anything back then. So my concern is that the mistakes are, and maybe this is armchair quarterbacking, right? Post this thing, but to me, this is suspenders in a belt, right? I think you mentioned the other day, do you want on the other bill, do you want suspenders in a belt? And I think sometimes I want suspenders in a belt in a law. I wouldn't wear it personally myself, fashion sense, but in terms of legislation, I don't think there's anything wrong with having suspenders in a belt, so the minister has clear powers to do what he or she needs to do. So I don't know, am I missing something on, I mean, you probably can't talk to the Tanko case, but.
No, I can't speak to specific cases.
No.
So if there are no more comments, we could vote on CPC 8 at this point. I see no other interventions, and we've heard plenty on CPC 8, so I would call for the vote, Madame Lagreffière.
Mr. Fillmore.
Against.
Mr. Sorbara.
Against, please.
Mr. Gahir.
Against?
Madame Lapointe.
Contre.
Mr. Van Bynen.
No.
Mr. Geneva.
Oui.
Mr. Perkins.
Yes.
Mr. Viss.
Yes.
Mr. Williams.
Yes.
Monsieur Lemire.
Contre.
Mr. Massey.
L'amendement CPC 8 est rejeté.
So the amendment CPC 8 is defeated, and this brings us to the end of our meeting. Thank you, Mr. Shan, Mr. Burns, and Mr. Carmen. I would like to thank the interpreters, the clerk. Thank you, everyone. The meeting is adjourned.